sir.
Your name?
Robert Biggin. Your Honor, today's time and date set for probable cause conference. I was appointed 2 days ago. I did get the discovery yesterday, and a lot of videos came in yesterday. I have not had the opportunity to review those with him. I'm asking for a 2-week adjournment.
Any objection?
The adjournment that I would like to address bond.
Probable cause conference will be adjourned to March 28, 2024, 9 a.m. as to bond.
Requesting either revocation of bond or to renew our request for $100,000 cash surety in this case.
Right out of the gate, this hearing takes a hard pivot from what looked like a routine probable cause conference into a full-blown bond battle. Defense counsel is basically saying, hold on, I just got mountains of discovery and video evidence yesterday, I need time. And that part is pretty standard. But the prosecution immediately changes the temperature in the courtroom by pushing for bond revocation or a massive cash increase. That tells you prosecutors already see this defendant as a serious risk before the deeper evidence is even unpacked. And notice how quickly Judge Simpson moves the calendar forward while still allowing the prosecution to raise the issue. That's courtroom efficiency mixed with caution. The second bond gets mentioned, everybody in the room knows freedom is suddenly hanging by a thread. This is where criminal history, community compliance, and public safety start outweighing sympathy. And viewers, pay attention to how often hearings like this stop being about just one charge and start becoming about the defendant's entire history and behavior pattern. That's exactly where this case is heading.
The revocation request is, we have received a community corrections violation. The defendant has never appeared at community corrections and has failed to ask for anything. So on that note, I'm requesting revocation of the bond and an immediate remand. However, in addition, at the time of charging this case, and before I go on, do you have the community corrections?
I do not.
I received it yesterday, Your Honor.
I sent it to defense counsel, and I can forward it to
Anne.
Provide you my copy.
Go ahead, Ms. Hughes.
At the time of charging this case, my office requested a $100,000 cash surety bond. The defendant does have an extensive criminal history in the sense that he has been convicted starting as far back as 2000. He was convicted of misdemeanor drug possession. In 2003, he was convicted of domestic violence. 2004, he was convicted of fleeing third. That's noteworthy here because this is a fleeing third case as well. In 2008, he was charged with but not convicted of domestic violence third offense. In 2011, he was found guilty of resisting and obstructing of a life offense of carjacking and another carjacking and an attempted. That is his most recent, those are his most recent felony convictions from 2011. From that case, he was sentenced to 2 years to 5 years in the Department of Corrections. This is a fleeing and firearm case now, and his guidelines on this case are 14 to 28 months without a habitual. So this is like that case, but at the very minimum, it doubles the 28 math that I believe is 59.
The prosecution is now stacking layer after layer of pressure onto this defendant, and this is the kind of presentation judges take extremely seriously. Notice the strategy here. They are not only talking about the current allegations, they're building a timeline stretching back decades. Drug possession, domestic violence, felony history, carjacking-related convictions, prison time. Prosecutors love doing this because it paints a picture of escalation instead of isolated mistakes. Then comes the dangerous driving narrative, and that changes everything. Once the state starts describing high-speed driving into oncoming traffic, fleeing police, and endangering the public, the courtroom mood shifts from defendant awaiting trial to potential public threat. And that matters because bond arguments are heavily tied to danger and likelihood of compliance. The prosecution is basically telling Judge Simpson, this isn't somebody who simply missed a step. This is somebody whose conduct keeps getting more reckless. Also, did you catch how they casually mentioned sentencing guidelines? That's another psychological move. They want the court thinking ahead to prison exposure already. The bigger the possible punishment, the bigger the alleged incentive to run.
I think that's correct. In this case, the defendant was driving erratically, so erratically to the point that he at one point was driving on the opposite side of the road into oncoming traffic in an attempt to evade the police. His speeds were, as far as I can see from the report, as high as 50 miles per hour in a 35 mile per hour zone. He put not only the police in danger, but also the community. Then, in addition to that, as you can see from the other charges, after the police, so at some point the police did have to terminate the word. Thank you. Chase pursuit. Thank you. Team effort. Because of how dangerous it was. Instead, they continued to follow him at a safe distance. Once he stopped the car, he got out of the car and continued to flee from the police on foot. While the police actually yelled at him, he was going to be shot. They were going to shoot him if he didn't stop running from the police. They were able to take him into custody, certainly without him continuing to assault and obstruct them first. Then, while they were inventorying the car that he fled in, they recovered a magazine from a handgun. This is a convicted felon, multiple times over. They knew, based on their experience, that typically where there's a magazine, there is a handgun. And they discovered a handgun on the route and he fled from them. In addition to that, however, they also found, they also suspected, that he was under the influence. So we are waiting for his blood results still. Refused any testing. The blood testing is still in the lab. And then, as you can see from your charges as well.
Now the prosecution starts tightening the screws even further, because this hearing is no longer just about fleeing police or violating community corrections. Suddenly, there's possible intoxication, a suspected firearm, and white powder evidence entering the picture all at once. And this is where prosecutors become very dangerous rhetorically. They begin layering uncertainty in a way that still sounds powerful. Notice the wording carefully. Suspected, waiting on blood results, testing still in the lab. They are intentionally presenting unfinished evidence while still framing the defendant as extremely risky. Then comes the firearm narrative. Officers allegedly recover a magazine, assume a gun must be nearby, and later discover a handgun along the route. For a convicted felon, that allegation alone dramatically raises the stakes. The courtroom atmosphere changes because firearms instantly trigger public safety concerns in a judge's mind. And viewers, this is the moment where bond hearings often become mini previews of trial strategy. The prosecution is planting themes early: danger, recklessness, disregard for authority, and possible substance involvement. They're building a narrative brick by brick before the actual trial even begins.
He was in possession of a baggie that had some type of white powder in it. This was something he left behind in the deputy's vehicle. Your Honor, I'm requesting either just straight revocation, bond denial, or his bond violation of failing to ever go to community corrections, or I'm requesting the $100,000, which was already requested in this case. Thank you.
Mr. Jervis.
Your Honor, he was arraigned on February 12th. He did post his cash or surety on the 18th of February. He had a PCC on 2/22. Everybody was in court the last hearing. That was not addressed regarding his testing. He obviously got out. He didn't go to community corrections. He was unaware at that time. No one reminded him on the 22nd. I got the bond violation yesterday at about 4:10. I called him and told him to go to community corrections immediately. Got back on the phone with him, told him they closed at 4:30 to show up at 8 in the morning. He was there 8 in the morning to try and do an intake. They would not take a test, or they would not do an intake this morning. He was told due to the bond violation. His mother is here with him today. He's obviously showing up to court. He's not driving. He was in his mother's car. As far as, minimally, I don't know the full facts of the case. I did start reviewing some of the video. I do understand that there may be another occupant to that vehicle. I'm not too sure on who the actual driver was of that vehicle, be with 2 occupants. So regarding, I'm asking that the bond remain. I'm asking that he report to community corrections today, allow him to do the intake, and continue on a testing.
Why didn't he go test?
That single question from Judge Simpson may honestly be one of the most important moments in this entire hearing, because once a judge starts personally drilling into compliance failures, the defense is officially in dangerous territory. Defense counsel is trying hard to frame this as confusion, missed communication, maybe even poor follow-up from community corrections. But the prosecution already established that the defendant was told to test after arraignment. So now the court is looking at a very simple issue. If you were ordered to comply, why didn't you comply? And the defense answer here is shaky at best. Nobody reminded him is not exactly the strongest argument when dealing with bond conditions. Judges expect adults, especially defendants already facing serious allegations, to remember court obligations themselves. What also hurts the defense is timing. The defendant only rushes to community corrections after the violation appears. That can look reactive instead of responsible. And let's be honest, viewers, when someone is already accused of fleeing police and resisting officers, failing to follow bond conditions becomes even more damaging because it reinforces the prosecution's narrative about non-compliance and poor judgment.
I don't know. And the other thing is no one reminded him the last time that was in hearing.
Okay, but he was told at arraignment to go test.
I understand. He was in custody at the arraignment and didn't post until 6 days later. So when he got out 6 days later, he didn't go and test. That is correct. And then he showed up 4 days later to his last hearing that got adjourned until today.
In regard to we don't know if he's the driver, he is being pursued by the police straight out of the driver's seat. They watch him get out to seat and they pursue him, they arrest him. So there's no break in that pursuit. I emailed community corrections yesterday asking for a community corrections update on him. Basically, I was looking for more fuel for this fire of this argument. They forwarded me that bond violation. I did not have a copy of it. It looks like the court didn't have a copy of it last time we were here.
We were here on what day?
The 22nd.
Something tells me that it was dated the 21st. I don't know what time it came. It actually is in my file, but I'm not sure when it came down because it doesn't appear that it was here the last time that we were here. When was he released from prison? 13.
This exchange may sound brief, but it tells you exactly what Judge Simpson is evaluating internally. He's trying to measure distance from prior criminal behavior versus signs of rehabilitation. Judges often look for long stretches of stability after prison release, steady employment, compliance, no violent allegations, no supervision issues. But here, the court is hearing about a defendant who allegedly engaged in another dangerous police pursuit while already carrying a lengthy criminal background. Then comes the absolutely brutal moment for the defense. The judge asks whether the defendant would test clean if sent immediately to community corrections. And the answer? Questionable. That is catastrophic in a bond argument. You could practically feel the momentum collapse right there. Because now the judge is no longer speculating about possible non-compliance. There's an open acknowledgement of likely recent drug use. That destroys credibility at exactly the wrong time. Viewers, hearings often swing on moments like this, not dramatic speeches. One uncertain answer can outweigh 10 polished arguments. And you can already sense Judge Simpson mentally moving away from leniency and toward tighter restrictions.
2013.
His parole is now expired.
Pardon?
His parole's expired.
Send him over there right now. Is he going to test clean?
The answer to that is questionable, but it will probably come back.
Questionable.
Well, I do have the belief that he at least used marijuana prior to the last few days.
And the defendant's bond is increased to $50,000 cash surety. Defendant's remanded.
Thank you, Ron.
Versus Ryan Johnson.
Morning, Your Honor. Marcia Craig on behalf of Mr. Ryan Johnson is approaching. If I may proceed, Your Honor.
Your name, sir?
Ryan Johnson.
Thank you. Go ahead. What are we doing?
As far as the PCC, my client is requesting a preliminary exam.
Discovery complete.
Yes, Your Honor.
People have their witnesses available the 26th.
Your
Yes,
Hon-
Your Honor.
Your Honor, I'm unavailable.
Your Honor, this is the co-defendant for Julius Clay. Are we wanting to keep them separate, Ms. Kracher, or are you inclined to keep them on the same day?
Just as one intense bond dispute wraps up, the courtroom immediately pivots into another serious criminal matter involving Ryan Johnson. And this one escalates fast. At first, it sounds procedural. Discussion about preliminary examinations, scheduling, co-defendants, witness availability. Pretty standard courtroom traffic. But then the allegations start landing one after another like bricks. Prosecutors claim two people, a parent and grandparent, were held at gunpoint. Then the situation allegedly escalates into a standoff serious enough to require SWAT teams and multiple law enforcement units. That is the kind of language prosecutors use when they want the court to see maximum danger and instability. Meanwhile, the defense is trying to humanize the defendant. Family ties, community roots, employment at Applebee's, support systems waiting outside the courtroom. That contrast is intentional. One side paints threat and chaos, the other paints stability and redeemability. And viewers, this is where bond arguments become almost psychological warfare. Which story feels more believable to the judge? The danger narrative or the rehabilitation narrative? Because that answer can determine whether someone waits for trial at home or behind bars.
My client insists a preliminary exam.
Okay, I would ask that we set it for the same day as Julius Clay so that we can have.
Mr. Clay's exam is what, the second?
Second.
That was adjourned, Your Honor, PCC.
Okay. So, but he's requesting his preliminary examination.
That's correct, Your Honor.
Can we go out to April 2nd?
Sure. Well, counsel approach. Back on the record, preliminary examination in this matter will be set for April 2nd, 2024, 9 a.m. That's in person before me.
Your Honor, my client insists that I address bond.
Go ahead, briefly.
Your Honor, my client has family here in the community. He's lived in the community for a long time. He indicates to me that his family would ensure that he would return to court. He also, prior to his incarceration, had a full-time job at Applebee's as a cook, which he would like to.
The allegations are that he held two people at gunpoint, a parent and a grandparent at gunpoint.
Those are the allegations.
And then took an infant to a hotel off the premises, which required SWAT and multiple teams of law enforcement to respond.
Go ahead with your argument, Ms. Carter.
He assured me that he would return to court. He would ask this court to, his bond, I believe, is currently at $5 million. He's asking for a
And I don't
reduction.
think that's high enough, given what I see here, but go ahead.
And he would be requesting a GPS tether.
Denied.
Thank you, Your Honor.
And there it is, the final collision between defense optimism and judicial skepticism. Defense counsel is desperately trying to chip away at a staggering multi-million-dollar bond by emphasizing employment, family ties, and promises to return to court. But Judge Simpson's reaction says everything. When the judge openly states that the current bond may not even be high enough, that is an enormous signal about how seriously the allegations are being viewed. Prosecutors framed this as an armed and highly dangerous incident involving vulnerable victims, a hotel situation, and a SWAT response. Once those facts enter the record, judges become extremely cautious about release conditions. Across both cases today, one theme dominated this courtroom: compliance and public safety. Whether it was fleeing police, missing testing requirements, or allegations involving firearms and hostage-style intimidation, Judge Simpson repeatedly focused on risk over convenience. That's the major takeaway here. Bond hearings are not about determining guilt. They're about determining danger, reliability, and whether the court believes a defendant will follow rules moving forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.